Mr. Chairman, my name is Matt Sousa. I'm here on behalf of myself. I'm also here as a representative of ACRE, which is a local
I can
organization.
hardly hear you, I'm sorry.
I apologize.
Would you be good enough to spell your name, please?
Certainly. It's Matt LaSousa, L-A-S-U-S-A. I'm a resident of Barrington, Illinois. I live at 68 ZBA Drive. I'm here on behalf, first of all, on behalf of myself. I'm also here on behalf of Timber Lake Civic Association. I'm also here on behalf of the organization ACRE. And I'm also here on behalf of my friends and neighbors in the audience. My point of order, this body, the Zoning Board of Appeals, has adopted certain rules for conduct of a public hearing. And I note at the outset that your rules of conduct differ substantially from those that are published by the Zoning Board of Appeals and have been used by the Zoning Board of Appeals in a number of matters. First and foremost, the Zoning Board of Appeals has adopted at file number 11-1169 rules of conduct for public hearing. These were adopted by the Board of Appeals on October 28, 2011, and they have been used extensively by the board in all of their hearings that have been conducted during the past year. In 2012 alone, these rules were used. I can do this by case number or file number if you prefer. January 12, case number 4717. January 26, case number 4728. February 2, case number 4672. February 9, 4757. February 20, 4474. February 23, case number 4706 and 4761. March 14, case number 4781. March 22, case number 4794. March 26, case number 4810. April 2.
Okay, what's the point?
There is a point. 20 times, 20 different meetings by the Zoning Board of Appeals, 2012 alone, you have used a certain set of rules of conduct for conducting a public hearing. This is the first time that this board is using a different set of rules for this particular public hearing, and they differ substantially from the rules that you've used in the past.
All right, let me stop you there. We can change our rules at any time.
I agree you can change your rules at any time, but we haven't published those rules and we haven't published to the public prior to this meeting. You did adopt these and publish them in accordance with law. You have not done that for this hearing. And I would like to point out differences between those rules and what's being promulgated here today. There is a purpose for this. For example, your original rule number 1, which is now your new rule number 4, preliminaries by the chairman, has new paragraphs C, D, and E. And they call for paragraph C, the identification of those individuals who have completed and submitted an interested party cross-examination appearance form. I submit to this board as a chilling form. It's designed to limit the public access to this board and their ability to give comment or cross-examine. Paragraph D, identification of those organizations that have completed and submitted a recognized organization presentation request form. Again, this is a new rule promulgated by the board specifically for this hearing, and I again submit that it has a chilling effect on the ability for people to appear and question the witnesses that are going to be presenting evidence and testimony here. Paragraph E, identification of those individuals that have completed and submitted a public comment request form. Once again, a chilling effect. It goes on, these rules don't just stop there. The new paragraph 6, which is the former published paragraph 3, the new rule reads, subparagraph D, questioning of each witness by those individuals that have submitted an interested party cross-examination appearance form. Now that differs substantially from the original, which said that questioning of each witness by the objector or objector's representatives, or subparagraph E, questioning of each witness by any person attending the hearing. So once again, by use of the form, asking people for their name, their address, the purpose for which